In March of this year, the Royal Courts of Justice ordered a High Court enforcement company to send the money they had collected to another enforcement company that also had a writ for that same debtor, on the basis that the second company had received their writ 36 days before. The judge ordered that priority existed between writs, and as such, the creditor that issued their writ first was entitled to their money first. So, what does this mean for the enforcement of debts from this point onwards? It's important to have an awareness of how enforcement has got to where it is today. We can do that by looking back to the old Sheriffs Act, which was enacted in 1878. It was in the Sheriffs Act that created a system where a creditor could obtain a judgment and send it to an undersheriff of the county where the debtor resided or did business. The undersheriff of the county would then send a warrant to his officers who would undertake the traditional enforcement work. That system was flawed, however, on the basis that as a creditor, the service they received and the likelihood of recovery was purely dependent on the ability of the particular sheriff. So, for instance, if the judgment debtor lived in London, then the writ would be sent to the Greater London Sheriff's Office. The creditors would then be entirely in the hands of that office and their specific abilities and service levels. This created frustration amongst the creditors who wanted better performance and to choose the enforcement company that collected their debts. Some creditors, for example, who had debtors in multiple locations around the country, had to deal with over 10 separate enforcement companies at the same time. Performance standards varied, and the entire model created a monopoly of geographical areas for certain enforcement companies. The debtor, however, was dealt with correctly and in line with the law, which is obviously vastly important. Debtors were only ever chased by the same sheriff, which kept enforcement fees to a minimum and prevented overzealous enforcement action. This is a very important point, as in March 2020, some 142 years later, Lord Justice Lewison handed a judgment down in favour of a Marston Group company against Court Enforcement Services, another enforcement company, where he made it clear that priority should have existed. The creditor whose writ is first delivered to an enforcement officer is entitled to their money first. This point of law, however, has been lost in translation over the years. The previous model continued for many years until the Office of the Sheriffs was deregulated in 2004 and undersheriffs were replaced by authorised High Court enforcement officers. The regional boundaries were lifted to provide competition between enforcement officers and provide fair choice to the creditors that employed them. The various monopolies were broken up in favour of a fair trading environment. The effect of this was that many of the smaller and less established companies were unable to compete with the larger firms with greater financial backing and were either absorbed by those larger businesses or simply ceased to trade. This created far fewer companies, but companies of greater scale and in some cases, ability too. The creditor got a competitive environment to purchase from, but the debtor's rights were pushed to one side. For the first time in history, a disorderly race between enforcement agents that favoured the most aggressive and least forbearing began. Debtors were now chased by tens of different enforcement officers at the same time and were required to pick up the cost of the 10 different enforcement actions also. This was the negative and unintended consequence of the 2004 change. And in March 2020, the Royal Courts of Justice, in the same case with Marston and Court Enforcement Services, made it clear for the first time in many years that not allowing for priority would permit a disorderly race between enforcement agents that would favour the most aggressive and least forbearing, which would be contrary to one of the policy objectives, which was to encourage proportionate and a staged approach to enforcement. The 2004 change without doubt resolved the issue on a monopoly by giving creditors choice and in many cases better performance. Unfortunately, however, by default, it also created an environment where some debtors were pushed into greater indebtedness. Through design, Just has resolved this issue, however. We have taken parts of the historic model and implemented the good intentions of the 2004 changes and designed an enforcement market integration approach. Through an integration model, a creditor receives access to an environment where competition is achieved by a multiple supplier per region approach. The enforcement company gets access to apply to work in any region across the country, and the debtor receives a fair, more proportionate and cheaper enforcement action. The value of the integrator model is that we manage the relationship with the creditor. We manage the data, intelligence and compliance stage of the collection process and oversee the process and performance of the enforcement market that we engage with to complete any physical enforcement activity that's required. The creditor gets access to a competitive marketplace, as was intended in the 2004 change. The debtor receives protection against multiple charges, as was intended in the 1878 rules. And the integration of the marketplace ensures performance and compliance with the relevant laws. Priority of the writs is achieved through sensible solution design. As Lord Justice Lewison said in his judgment in March 2020, the principle of priority is to ensure logical, just and proportionate enforcement process where the creditor who takes legal action first is given priority, and that the debtor is not on the receiving end of aggressive enforcement tactics. The enforcement market integration model is the only model that solves the issues created by the 2004 changes and were identified by the Royal Courts of Justice in March of this year. The greater number of creditors that use market integration as an approach to enforcement will substantially increase the number of debtors that are treated fairly and in line with the law. We believe that everyone has the right to be paid what they're owed, but it's just to do it right.